I call Ria Bond.
Speaker, I'm pleased to rise on behalf of New Zealand First and take the second reading for the Patents, Trans-Tasman, Patent Attorneys and Other Matters Amendment Bill. Mr Speaker, New Zealand First supported this bill to the Select Committee in my first reading, and at the time it seemed like this bill was a pretty straightforward bill, and that this bill had all the answers to fix all the outdated issues, the poor drafting results and what was wrong for the patent profession. In my first reading, I referred to the comprehensive redrafting of the New Zealand Patents Act 2013, which took effect in September 2014. This, at the time, was a mammoth exercise, which we saw sweeping changes introduced to the Act, and now 18 months later, here we are again in the House fixing unintended consequences of this bill. So that is why New Zealand First did support the bill in the first reading to go to the Select Committee process so that it could go under the scrutiny that this bill needed to have. When the bill came to the Select Committee, we were also provided with advisors, which is a normal process. Mr Speaker, I believe that when advisors are appointed to any Select Committee, that the chief purpose of the advisors is to be the specialist to those members of that Select Committee. So that, therefore, that they are to provide documentation, evidence, facts, things that actually could be wrong with the bill, recommendations that we needed to consider when going through the bill under that scrutiny process. Mr Speaker, I absolutely believe that advisors need to be professional at all times, they need to be organised, they have to be informed, and they must treat members with respect. And above all, Mr Speaker, I believe that should there be any potential personal interest in a bill and its passage through the Select Committee and this House, then it should be treated with the profession from advisors that I would expect them to give to a bill. Mr Speaker, I don't wish to slam the advisors too heavily, but I do feel really strongly about the lack of transparency. I felt at the time quite concerned over the fact that when advisors were pushed, they really didn't want to give members the answers that we wanted, like the cost analysis to the implementation of what we were expected to be informed about with the advisors. I found that that whole process was a Mickey Mouse outfit. I found that it was like drawing blood out of a stone to get the advisors to ask particular questions. So I echo what other members in the Labour Party have said this evening, that the performance of the advisors overall was really poor. Had I known that there was a process that members were actually privy to perform, at that time I would have actually insisted on that and had an outcome happen with those advisors. So I believe it was a hindrance to the members and it was really frustrating. So, Mr Speaker, through my contribution tonight, I will address why this bill is still not fit for purpose, and I cannot understand why, after what the Labour Party and Green Party have just said, why they are still supporting this bill. Mr Speaker, it's critical that this bill needs buy-in from the profession itself and the industry, and I feel that with the amendments there and with the submissions that came through, they still do not have buy-in to this bill, Mr Speaker, and I think it's imperative that we make the right choices. We look after the industries that we say that this bill will look after. There was 20 submitters that came to the Select Committee. We heard from 6 oral submitters and there were 2 supplementary submissions. And as has already been echoed through the House, there was an absolute overwhelming opposition for the patent attorneys from the submitters to do with the SAP and the SEP, which was aimed to implement a pilot project to see if this project would work across Australia and New Zealand jurisdiction. However, the advisors advised the Select Committee that a new electronic procedure for filing patent applications had been put in place by the World Intellectual Property Organisation, WIPO for short, and this was not only endorsed by the industry itself but used effectively, and they had alerted the advisors that the pilot project preferred by our advisors would actually make the SEP and the SAP undesirable, therefore redundant. This issue was what we had as New Zealand First when considering the bill, Mr Speaker, and that is what raised a red flag. So I just want to also add to the fact that had the SAP and SEP not been removed from this bill, it would have put an absolute financial burden on the patent profession itself. Now, what I do want to address is that clearly the Minister did not, or he was not aware that the proposed SAP and SEP by his advisors was merely a pilot program the advisors wanted to put to the test through legislating a pilot program inside of this bill which, when it came into the House, was on the 9th of February this year, and they wanted this pilot program to be put inside of this bill so that it could be tested to see whether or not it was going to be successful. And, Mr. Speaker, I seriously ask the question, how is that being responsible with the time that we have in this House to try and legislate on a simple pilot program because of the belief from an advisor that this would work here in this country? So, Mr. Speaker, in terms of the submitters that came into the House, I actually was alerted to the fact that they felt that they were absolutely not consulted with at all, and that their industry overall performed quite well, and that the first that they knew that there were issues was actually when this bill came to the House. And I'd like to actually read some of the concerns from the submitters, specifically a submission from the New Zealand Institute of Patent Attorneys, where they say, "It is our view that consultation with the New Zealand profession has focused solely on how a joint registration regime should be implemented rather than on whether it is wanted or required or how it would benefit New Zealand businesses and/or the New Zealand patent attorney profession." Now, the NZIPA can only see increased costs and compliance for the New Zealand profession as a consequence of joint registration. Another submitter, Mr. Matt Adams, stated, "We don't seem to have been consulted on whether we want a joint registration regime. The assumption is that we need one." The assumption was that they needed one. If we are going to go down this route, we need to make sure that we have a level playing field. What I see proposed needs amendment to ensure a level playing field. Now, another question that came up was the qualification pathway of patent attorneys through this proposal. And a very well-known submitter with a lot of credential in this field itself actually submitted about the fact they were worried about the watering down of patent attorneys here in New Zealand and being overtaken by the Australian system. And what this submitter, Elise Buchanan, has said in her submission, "Further, since New Zealand will have only a tiny representation on the Governing Council, it will be very easy for the Governing Council to set, for an example, continuing education requirements and training requirements to suit the Australian profession only. As matters stand at present, it is doubtful whether it is going to be possible to train patent attorneys in New Zealand in the same manner as prescribed in Australia. If, in fact, all training has to be done in Australia, this is a truly enormous cost burden for any of the New Zealand firms, and the end result could easily be that New Zealand firms cannot accept trainees. Persuading Australian staff to come across to work in New Zealand firms, which in general pay substantially lower salaries, is extremely difficult, and it is not scaremongering to predict that the New Zealand patent attorney profession could in fact cease to exist within a few years." Now, Mr. Speaker, that was a huge concern when we were within the Select Committee listening to the submissions. So, Mr. Speaker, in closing, New Zealand First is absolutely not in favour of supporting bad legislation, and this bill is no different. Sadly, the National Party have brought bills like this to the House on many times that are written badly, not fit for the purpose, and not fit for the profession that they say they're going to protect. And this bill does not justify the fact that the government have been forced to do a complete U-turn to scrap the SEP and the SAP, and have still continued to ignore what the majority of the submitters said, that we are an industry that act above what the expectations of New Zealand are, and this bill is going to do nothing but wipe us out. Thank you, Mr. Speaker.